Silence is the loudest move he's making right now. Donald Trump has gone quiet at the exact moment his past is getting louder, and that contradiction is the story. Fact. While allies post photos of him golfing with his granddaughter and he floats headline-grabbing distractions like talking about invading Greenland or Canada, attention keeps snapping back to one thing he isn't talking about: the Epstein files. Fact. The idea being pushed is that if he goes radio silent, people might just forget the cover-up. But here's the part nobody is saying out loud: forgetting doesn't happen when the justice system starts stalling in public. This matters to you because what's unfolding isn't just about Trump or Epstein. It's about whether the system meant to prosecute crimes can suddenly claim it's too busy to function. Fact. The Department of Justice has told federal judges it is not prepared to move forward on other major criminal cases because its lawyers are tied up reviewing Epstein documents. That's not gossip. That's happening in courtrooms. Notice the paradox. The DOJ says it's overwhelmed now, but fact. Back in late February, the Attorney General announced Phase 1 of the Epstein files was already complete. Fact. Around that same period, nearly 1,000 FBI agents and lawyers were reported to be working on the review, billing massive overtime. So here's the question that reframes everything. If this work has been ongoing for months, why are judges only now being told the system can't handle anything else? Now, watch how fast this flips, because once prosecutors start blaming the Epstein review for delays in unrelated trials, the silence stops looking strategic and starts looking defensive. And the next detail comes straight from inside the DOJ itself. Here's what's actually happening, stripped of the distractions. In fact, multiple federal prosecutors have gone into court and told judges they are not ready to proceed in unrelated criminal cases, not because evidence is missing, not because witnesses disappeared, but because, according to the DOJ, their lawyers are tied up reviewing the Epstein files. That's the core event. But notice how little of it has been fully explained. This isn't one courtroom. Fact. This is centered in the Southern District of New York, one of the most powerful prosecutorial offices in the country. Fact. The DOJ told judges overseeing the Nicolas Maduro case and a separate major sex trafficking trial involving Florida real estate brothers that resources were being diverted. Judges didn't hear this quietly. One of them pushed back, openly questioning how the federal government could claim it lacks capacity. That reaction matters. Now frame this as a pattern, not an accident. Fact. Just months earlier, the Attorney General publicly announced that Phase 1 of the Epstein file review was complete. Fact. At that time, hundreds, later reported as nearly 1,000, FBI agents and lawyers were assigned to the same task, billing extensive overtime. So why is the same review now being cited as the reason other prosecutions can't move forward? Here's the cognitive shift. If transparency was already underway, why does it suddenly function like a bottleneck? And why does it appear only after scrutiny intensifies? This is where the story flips, because the delay itself becomes evidence. And the first proof is already on the record. Here's the first hard claim, and it's not subtle. Fact. The Department of Justice is telling judges it cannot prosecute active criminal cases because it is reviewing Epstein documents. That's not commentary. That's what was said in court. In one instance, prosecutors handling the Nicolas Maduro case admitted their work had been diverted. In another, a defense lawyer in a sex trafficking trial said, on the record, "We have a trial starting next week, Your Honor," while the government still hadn't finished reviewing seized evidence. That detail matters because of who said it and where. Fact. This is happening in the Southern District of New York, the same office described as one of the main hubs for the Epstein review. Fact. Attorney General Pam Bondi wrote that nearly 2/3 of roughly 200 lawyers in that office were spending all or most of their day on Epstein-related document review. That's not a rumor. That's a formal explanation to the court. Now notice what's missing. No clear explanation of why this review, which was described months ago as already underway or even partially complete, has suddenly consumed the entire office. No timeline, no accounting for what happened during the months when... Fact. Hundreds of FBI agents and lawyers were reportedly assigned to this exact task, billing tens of thousands of overtime hours. If that work was happening from March through May and possibly June, what changed? This is where the story tightens, because when a justification doesn't add up, it stops being an excuse and starts becoming the evidence. And the next move shows just how defensive this has become. Now watch how this escalates, because the response isn't to speed things up, it's to lock things down. Fact. Members of Congress, including Thomas Massie and Ro Khanna, asked a federal judge in the Ghislaine Maxwell case to appoint an independent monitor to oversee the release of the Epstein files. Their argument was simple. The DOJ cannot be trusted to police itself on this issue. That request alone tells you how far confidence has eroded. Here's what happens next. Fact. Late on a Friday night, the DOJ filed papers arguing that Massie and Khanna don't even have standing to make the request. Not because it's unreasonable, not because transparency is already working, but because, according to the DOJ, no court has the authority to enforce the Epstein Transparency Act at all. That's the argument. Fact. The DOJ claimed the law provides no private cause of action and gives courts no power to compel transparency. This is where the normalization sets in. A law named for transparency is being used to argue that transparency can't be enforced. Read that again. And notice the shift. Instead of saying, we're working on it, the position becomes, no one can make us work faster. That's not delay. That's insulation. Here's the comparison that matters. Historically, when agencies are overwhelmed, they ask for time. When they're challenged, they explain. But here, fact. The DOJ's move is to shut down oversight entirely, while simultaneously telling judges in unrelated cases they can't proceed because Epstein is consuming all resources. That contradiction should not be normal, but it's being treated like it is. And once oversight is blocked, the pressure doesn't disappear. It moves somewhere else, into active trials, into real courtrooms, and into consequences that can't be delayed. Now, the pressure stacks fast. Fact. While the DOJ argues in one courtroom that no court can enforce the Epstein Transparency Act, it's simultaneously telling other judges it can't meet basic prosecutorial obligations. Fact. In a high-profile sex trafficking case involving two celebrity real estate brokers and their brothers, a defense lawyer complained the government hadn't finished reviewing seized evidence that legally must be turned over before trial. The trial was starting the next week. Then comes the moment that cuts through everything. Fact. The judge in that case, Valerie Caproni, suggested that perhaps a few people could be sprung from their Epstein obligations to do the government's job. And then she added the line that quietly detonates the entire narrative. That seems reasonable, she said, given the fact that these people are on trial and Epstein is dead. That's not commentary. That's a federal judge on the record. Stack the implications. Fact. Active defendants are waiting. Fact. Alleged victims are waiting. Fact. Trials are being delayed not because of complexity, but because resources are locked in a document review tied to a case that's already concluded. At the same time, fact. More than 3,000 people have reportedly quit the Department of Justice over the past year, far more than under prior administrations. Less staff, more pressure, zero margin for error. What happens when a system under strain chooses to freeze instead of prioritize? Because if this continues, it doesn't just slow justice. It reshapes who gets it and who doesn't. Now shift the camera to where this actually lands, on you and on people who don't get to wait this out. Fact. When prosecutors delay turning over evidence, trials slow down. When trials slow down, people sit in limbo. Defendants wait. Victims wait. Families wait. This isn't abstract. It's lived time. Imagine being involved in a federal sex trafficking case and hearing that your trial might stall. Not because facts are unclear, but because prosecutors are tied up reviewing documents from a completely different case. Fact. That exact complaint was made in court, and the judge didn't dispute it. She acknowledged it. That's the moment where the story stops being about Epstein and starts being about everyday consequences. Here's the part most coverage skips. Delays don't just affect outcomes, they change leverage. Fact. The longer a case drags on, the more pressure shifts. Witnesses move, memories fade, costs rise, and for anyone caught in that system, justice starts to feel conditional, dependent on staffing levels, political pressure, and which files get priority. If this feels familiar, say so in the comments. Because a system that can pause real cases indefinitely isn't just malfunctioning, it's signaling what matters more and what can wait. And once you see that, the next question isn't who's to blame, it's how this structure keeps reproducing itself. Here's the deeper mechanism at work, and it's quieter than outrage. Fact: when institutions face pressure they can't resolve, they don't always collapse. Sometimes they reroute. Incentives shift. Accountability gets diffused. In this case, the Epstein files become more than documents. They become leverage, a justification that absorbs time, staff, and scrutiny all at once. Notice the structure. Fact: the DOJ tells courts it's overwhelmed. Fact: it tells other courts they have no authority to intervene. And fact: it points fingers elsewhere, even suggesting that judges themselves are slowing things down. That combination matters. It creates a loop where delay explains delay, and no one inside the system is empowered to break it. This is why spectacle plays such a role. While attention bounces between headlines, invading Greenland, invading Canada, family photos on a golf course, the actual mechanism grinding forward is procedural, slow, legal, boring enough that most people tune out. But here's the unsettling insight. Systems don't need secrecy to avoid accountability. They just need complexity, exhaustion, and enough plausible explanations to keep things moving sideways. And once a system learns it can survive by stalling, by turning transparency itself into a bottleneck, it doesn't rush to fix that behavior. It repeats it. Which brings us to what happens next, because momentum like this doesn't stop on its own. Now look ahead, because this story isn't frozen. It's moving, just not in a straight line. From here, there are two paths, and neither is theoretical. Fact: one path is acceleration. Courts push harder, judges start forcing timelines, congressional pressure escalates. The longer prosecutors cite Epstein as a blocker, the more that justification itself gets examined. And once that happens, silence stops working. Every delay becomes a question, and every question becomes a record. But there's a second path, and it's quieter. Fact: delays normalize. Cases get rescheduled, resources stay stretched, oversight arguments bounce between courts without resolution, attention drifts. In that scenario, nothing explodes, it just settles, and when it settles, the precedent locks in. Transparency can be promised loudly, while accountability moves slowly enough to lose urgency. Here's the unsettling part. Both paths can coexist for a while. Pressure in public, drift in practice. That's why the next move matters so much, and why it's likely already forming behind the scenes. Because whichever path wins won't be decided by one headline. It'll be decided by what happens the next time a judge asks a simple question: why is this still not done? Here's the insight that ties all of this together. Silence wasn't the absence of a strategy, it was part of it. Fact: while public attention was redirected, the real battle moved into procedure, staffing, and jurisdiction. Not dramatic moments, administrative ones. That's where outcomes quietly harden. Reframe the story in one sentence. This isn't about what's being released, it's about what's being delayed and who pays the cost of that delay. When a justice system can point to transparency as the reason justice slows down, the meaning of transparency flips. It stops being a solution and starts being cover. And this loop doesn't end with one case. It sets expectations for the next one and the one after that. If silence can buy time, time becomes power. And power, once learned, gets reused. This is why the next layer matters, because what's happening here isn't isolated, and the deeper pattern is already visible if you know where to look. If you want to stay ahead of it, follow and subscribe. We'll keep breaking down what moves next before it becomes obvious.